4, 3, 2, 1. Action.
And welcome to the greetings from the ICD in the house, and welcome. This webinar is dissecting the federal and they are the formulating the a special welcome to those who are tuning in live at Kabarak Law School in the ICD. So, on the other place, Kenya third general election of the Constitution of Kenya 2010. On 15 August 2023, the chairperson of the INDC declared William Samoei Ruto the president-elect. Agreed by the results of the process by which we have been seen, Raila Odinga and other petitioners moved to the Supreme Court to determine this result. On 5th of September 2022, after a very rigorous process, the Supreme Court rendered a brief decision on the matters that they found. On 26th September, they gave the judgment, which is what we was actually. So I invite you there to discuss with us and talk with us on the journey of unpacking the decision. I would invite you to also follow the institution that are convening this discourse, which is Kabarak Law School, Katiba Institute, and Judicial. You can also see what it is with the other group and this kind of discussions. So I'm going to invite my co-moderator to introduce our members to you.
Gathered here and also on.
Professor Simana was JSC Lord intellectual policy, education, and constitutional. He also has a lot of the University of Nairobi Law Schools. He has one practice
as an advocate of the High Court of Kenya for at least 29 years. Professor Sihanya possesses knowledge, experience, and interests in constitutional democracy, electoral justice, and political lawyering of over 33 years in experience. In addition to research in these fields, Professor Sihanya has litigated and advised on numerous constitutional, electoral law, and policy cases in Kenya, Africa, and around the globe. Professor Sihanya has argued numerous substantive cases before the Supreme Court, the Court of Appeal, the High Court, Magistrates' Courts, and numerous tribunals. He has helped promote electoral justice, constitutional democracy, and the rule of law through numerous roles in litigation. He has consulted with various governmental ministries and departments and diverse organizations, which include the Ministry of Education, the Ministry of Science and Technology, which is within the Ministry of Education, Trade, Industrialization, the Ministry of Justice, the National Cohesion and Constitutional Affairs Department, the Ministry of the East African Community, the Committee on Eminent Reforms, also known as COEP. Professor Sihanya has consulted for CSOs, PBOs, and nonprofits, including the Law Society of Kenya, the East African Law Society, this International Commission of Jurists here in Kenya, Kituo cha Sheria, the Federation of Women Lawyers. Second on the panel, we also have Professor John Hudson. Professor Hudson is an L. Bates Lear Global Professor of Law at the University of Michigan Law School and a professor of legal history and director of the Institute of Legal and Constitutional Research at the University of St. Andrews in Scotland. Professor Hudson's teaching and research focuses on 9th to 13th century England and Northern France, particularly in the fields of law, lordship, and literature, as well as historical writing and the late 19th century study of medieval England. Some of Hudson's books and publications include a volume of the Oxford History of the Laws of England, the history of the Church of Abingdon, the formation of the English common law, a renowned book titled Land Law and Lordship in Anglo-Norman England. He's also co-editor of Patrick Wormeld's papers on the preparatory to the making of English law, amongst many, many other publications. Thirdly, on the panel, we're also honored to have our Dr. Muthomi Thiankolu. Dr. Thiankolu is a partner at Muthomi and Karanja Advocates here in Kenya and a lecturer at the University of Nairobi School of Law. His professional interests are in public procurement regulation, dispute resolution, electoral and democratic processes, constitutional and administrative law, and international economic law. He's an accomplished legal practitioner, consultant, and academic, and he was actually part of the respondents' legal team in the just concluded Supreme Court presidential election petition. Dr. Thiankolu has published many peer-reviewed journal articles and book chapters. He has appeared in the East African Court of Justice, as well as many other courts within Kenya, all the superior courts within the Republic of Kenya. Dr. Thiankolu has provided legal consultancy services to the Bretton Woods institutions such as the World Bank Group, the IFC, the United Nations Office on Drugs and Crime, UNODC, the German Cooperation, GIZ, the Judicial Service Commission of Kenya, the Public Procurement Regulatory Authority in Kenya, the International Development Law Organization, also known as IDLO, the Law Society of Kenya, the Research Foundation of the State University of New York. We also have online our senior lawyer and lecturer, Luciano Thuo. Counsel Thuo is an advocate of the High Court of Kenya, a lecturer and associate dean at Kabarak University School of Law in Nakuru, Kenya. She holds a Master of Laws degree in Human Rights and Democratization in Africa. And this is from the Center for Human Rights at the University of Pretoria in Pretoria, South Africa. She also has a diploma in realizing human rights through criminal law from Abo Academy University in Turku, Finland. She has served as a research coordinator for the Judiciary Committee on Elections in Kenya and the Political Parties Disputes Tribunal. Her research interests include election law, disability rights, public international law, international humanitarian law, and international human rights law. Fourthly, on the panel, we have our counsel, Dudley Ochel. Counsel Ochel is a practicing advocate of 9 years experience and has extensive Supreme Court experience in Kenya. He holds an LLM in Law, Governance, and Democracy and a Bachelor of Laws degree from the University of Nairobi. He's an arbitrator and a certified professional mediator. Ochel is a current board member at the National Council of Law Reporting in Kenya, and he works as a senior litigation and research counsel at the Katiba Institute here in Nairobi. He is the 2018 Public International Law Pro Bono Jurist of the Year, and his active memberships include participating in the International Society for Public Law, African Network for Constitutional Lawyers, Environmental Lawyers Alliance Worldwide, International Lawyers Assisting Workers Network, International Commission of Jurists, Cartoonists Legal Advisory Network, and the Legal Empowerment Network. He's affiliated with the Media Defense Institute, MLDI, and is a member of the Law Society of Kenya Public Interest Litigation and Human Rights Committee. We're also honored on our panel to have senior counsel, JV Owiti. He's our sixth panelist. Counsel Owiti is a principal prosecution counsel working in the Office of the Director of Public Prosecutions. He holds an LLB from the University of Nairobi and a Master of Laws degree in Law, Governance, and Democracy, also from the University of Nairobi. He also holds an additional LLM in Public International Law with a specialization in International Criminal Law and a PhD. He's currently a PhD candidate specializing in law, governance, and democracy, also at the University of Nairobi. His interests include law, governance, and democracy, criminal law, international criminal law, and anti-corruption law. So we look forward to hearing from all our eminent jurists this afternoon. And I'm going to hand over back to Julie. Thank you.
Thank you very much, Valentine, for the wonderful introduction of our panelists today. Now, it is my distinct pleasure to invite Ms. Elsie Saina from the International Commission of Jurists to give brief opening remarks on behalf of the convening partners and ideally guide us into the webinar. Over to you, Elsie Saina.
Thank you very much, Julie. Good afternoon, everybody. I hope you can hear me very well. It's my distinct honor and pleasure to welcome everybody to this wonderful webinar, which we've partnered between ourselves, ICJ Kenya, the Katiba Institute, and the Kabarak School of Law. We are really delighted to welcome all the distinguished panelists, our fellow jurists, civil society present, scholars, academicians, the students, the law students who've joined us this afternoon, and all our partners. Allow me to start with a very short quote from one of the leading jurists that we admire here at ICJ Kenya. His name is Waikwa Wanyoike. Waikwa says, in a democracy, the final word lies with the sovereign, who are the people and not institutions. Our sincere hope here this afternoon as partners is that this will be a hallmark of our discussions this afternoon. Ladies and gentlemen, one of the most essential aspects of our democracy is the effectiveness and continuity of the independence of the judiciary and its ability to uphold the rule of law. The rule of law provides confidence that what is true today will certainly be true in the coming years. The predictability of the rule of law is what many Kenyans and many distinguished partners and fellow jurists yearn for. It undergirds the resilience necessary to absorb the inevitable shocks of any political system. It is, after all, our judiciary that has the responsibility to ensure that the struggles of the citizens of our country engage with each other through their freedom of expression as guaranteed in the Constitution, whether it's through ideas, political views, politics, issues on social values, are resolved peacefully, sensibly, and fairly. And that those conflicts do not overwhelm or undermine the civil society or academia and that allows for the continuity of vibrancy of those debates in furtherance of our democratic values and principles. Ladies and gentlemen, the public debate is at the very heart of how democracy functions. For our people to govern themselves, either directly or by its representatives, it must be able to forge enlightened opinions on questions of problems which concern them. This debating process is seen as necessary for citizens to be able to make choices upon which public policies can be developed and which influence collective destinies. Important to note, ladies and gentlemen, is that these discussions are not abstract exchanges that will take place in a fanciful world of ideas. The debate today will be our entry point into developing a detailed analysis of the 2022 presidential election petition, and will be our entry point also as civil society and academia in sustaining our advocacy work in ensuring that the 2027 general elections is free, fair, transparent, and credible. As I conclude, ladies and gentlemen, allow me to say that in order for us to make informed decisions, people need to be able to discuss their options and their opinions, and they need to debate this openly without fear of reprisals or persecutions. Public debate continues to be a crucial way for our people to receive information that will help them understand complex technical issues. It is my hope on behalf of all the partners, and including myself, that at the end of this webinar, all participants, including myself, will be more enlightened and knowledgeable from the discussions. So on behalf again of the ICJ Kenya Council, the partners here this afternoon, Katiba Institute, the Kabarak Law School, ICJ Kenya, we welcome everybody to enjoy this wonderful afternoon and deliberations. Thank you very much. Over to you back at the studio. Thank you, Julie.
Thank you, Elsie. I'll now invite my co-moderator to start us off.
So I would like to call on Ms. Christine Konge, the Executive Director of Katiba Institute. Oh, I beg your pardon, I'm told she's unavailable. So I think we'll go straight on to the questions from now. And the first question that we'd like to tackle regards the language that was used during the Supreme Court petition ruling. Social media was abuzz with discussions centered on the language of the court. What are your views? Please, Counsel Owiti, if you could give us about 10 to 15 minutes of your views.
Thank you very much. It's first of all such an honor to be debating Mwalimu Tiankolo. We've had this debate on social media, and I'm glad that now we brought it out here in the open. I must start by saying that the intention here is not to criticize the court, but there is a view in which I have reconsidered the language that was employed by the Supreme Court in the 2022 presidential election decision, which I have trouble with and has nothing with the merits of their decision. We have seen it has now become commonplace for words like hot air, words like wild goose chase, and many other words that personally I find uncomfortable when used not just by the Supreme Court, but any court of the land, including the subordinate courts, the magistrates' courts. So when judges are recruited, one of the things that we look at is the temperament of the judicial officers, their ability to be provoked by parties, but still take it in without unloading such kind of stress or anger on the parties. But then it becomes a little more complicated when what we are talking about is a presidential election decision, because a presidential election petition is larger than the parties themselves. It is larger than the council representing the parties, especially in Kenya, where such an election of a presidential level is closely contested. So temperament requires that a judicial officer, even when they give a decision that aggrieves one of the parties, as is the case in our adversarial system, then they give it in a language that the loser does not feel double prejudiced. Prejudiced in the form that they've lost in the decision, and further that there is salt added to the injury in the manner that their loss is served to them. I have read the decision of the Supreme Court of Kenya once, twice, and 3 times, and I have not seen any value that the words wild goose chase, the words hot air added to the jurisprudence or the jurisprudential value of that particular decision. What it has done is that the parties that appeared before the court, including their counsel and the supporters, because this was a great public interest matter, have been left injured, and some of them are still recovering from the injuries of the words. It's like it is not enough to have lost the election on the merits. It is not enough to have lost the battle in court on its merits, but the court wanted to make you feel and remind you that you are a loser. So there has to be a distinction. And I know Senior Mutomi is going to have a rebuttal of this. We are not saying that there were no problems in terms of the conduct of counsel appearing before the court. There actually was a lot of problem in terms of the behavior of counsel, but that the Supreme Court has sufficient tools to deal with cases of misconduct and cases of alleged forgery or actually confirmed forgeries before the court. The way to deal with that does not include the employment or involvement of what would be called strong language. To add on that, apart from the temperament, judicial officers are required to be impartial. Impartiality, just like justice, should not just be done. It should be seen to be done, where supporters of a candidate, from the language employed by a judicial officer in an adversarial system, feels that, or rather could ask questions, but why is the court saying hot air, a whole lorry load of evidence, hot air? Does the court have something more than just the merits of the case? So my view is the court could still have reached the same decision it reached if the court intended to sanction advocates for misconduct or any other thing that the court felt was not done properly. The court should have made recommendations to the advocates disciplinary committee or cited these particular fellows for contempt, which the court has power under Section 28 of the Supreme Court Act. And at the same time, the court could still recommend investigations and charges under Section 113 and 114 of the Penal Code. So the language that the court decided to employ was not necessary because it led to hurt of the losers, and it led to hurt amongst the supporters of the losers, this being a matter of great public interest.
Thank you, Council Owiti. So now I'm going to ask Dr. Muthomi. Please, can you give us your views on the lingo that was used?
Many thanks, Val. For me, the starting point is to understand what is language and what is its role in human interactions and human affairs. My own basic understanding is that what distinguishes us from the other animals in our ecosystem is our ability to communicate through coherent language, to pass ideas, to communicate feelings, to describe various phenomena. And if we agree that language is no more than a tool of communication, if we also agree that to the extent that we live in a society governed by certain norms, then it is expected that the lexicon of any language will be heavily laden with social values, or it will be normative in character. And if we accept all these things, then it must follow that the purpose of language is to express various feelings, various ideas, and they include indignation, they include happiness, they include sadness, they include reprimand and whatnot. It cannot be that the purpose of language in any one human context is to assuage the fragile ego of the person being communicated to. It cannot be that the purpose of language is to placate people who lose cases. When I listen to my good colleague, Mr. Owiti, I hear him saying that the judiciary has a duty to placate losers. And I'm not aware there is such a duty, whether in law, whether as a matter of judicial practice, whether as a matter of case law. The duty of the courts is, number one, to decide cases on the evidence, on their merits. And in the course of so doing, in my view, the court is also entitled to express its approval or disapproval of behavior that is either unprofessional, behavior that is criminal. And for me, if we accept that, then I usually like flipping the coin. Suppose these advocates who had committed these serious crimes, in my view, these serious acts of professional misconduct, suppose the Supreme Court had described them in very complimentary language, saying they are such awesome guys, they are the embodiment of appropriate standards, and therefore young lawyers should be emulating these forgeries and whatnot. Would we have problems with that language if it wasn't, if it was in the opposite extreme? And the point I'm trying to pass is that on the circumstances of this case, I am not persuaded that there was anything wrong with the language, whether as a matter of semantics, that is to say, as a matter of the grammatical meaning of the phrase hot air, or as a matter of the grammatical meaning of the phrase wild goose chase. Because on the facts of the case, we had litigants and their lawyers filing with the court not just one forged document, not just two forged documents, but a forged document on top of another and another, in short, a heap of forged documents. We saw advocates making claims that no reasonable person, let alone an advocate of the High Court of Kenya, would make on such a solemn occasion. And I think we are being unfair to the court. My own understanding is that the court is entitled to express disapproval in the strongest terms possible. And on the facts of this case, actually the words that were used, there was nothing strong about them, not as a matter of dictionary meaning of those words. On the context, given the facts of the case, then the language, in my view, was actually polite. And what I have not understood in this discussion, which is perhaps what we should be discussing, I have been struggling to understand the principle upon which a party who commits perjury, a party who submits forged documents, a party who files before the highest court in the land a case that he knows or he ought to know that is the most frivolous of the cases of that type ever filed in our courts. I'm struggling to understand on what principle would such a party be entitled to take the moral high ground when he's censured by the court to say, no. I may have done all these things, but you cannot criticize me. You cannot use strong language against me. And in short, my point is, even if it were true, that my submission is that it is not true, but even if it were true, that the court had used strong language on the facts of this particular dispute, actually the persons complaining against the court would have no valid reason to either feel offended or to complain at all.
Thank you, Dr. Counsel Witu, would you like to respond to that briefly?
Yes, just two things. Let me start from the last point that Mwalimu has just made. Like I've indicated earlier, the Supreme Court presidential election decision is larger than the parties. So that even if there was no moral basis for the parties themselves and their counsel to raise concerns about the language, the other Kenyans who are the subjects and the recipient of the service of the Supreme Court are entitled, like we are doing now, to question the choice of language that the court employed. Number two, the critique or criticism as to the language employed by the court does not equate to a justification of the misconduct by the counsel before the court. There's a possibility that counsel could still be punished for the misconduct without the employment of the language. Allow me to make the final, the third point, and I will make reference to paragraph 313 of the court. When the court itself cries about the choice of language by counsel. So this is not us only making a complaint about the court. The court itself in the judgment says this, if you allow me to read at paragraph 313. Unfortunately, our caution went unheeded. Some counsel and parties have used inappropriate and insulting language against the court, even before the issuance of our detailed judgment. It ought to be appreciated by all that given the adversarial nature of our legal system, a determination of any matter by a court of law can never be in favor of both sides of the contending parties. While a party or its counsel may understandably be aggrieved by a decision of the court, it does not help or take away such grief by resorting to insults or vitriolic attacks on courts. This is what my argument is. The court acknowledges the place of language in court. Then that means that the court should take the highest ground in promoting proper use of judicial language. If the court can complain about the language employed by counsel, then it is proper for Kenyans to also remind the court that you should lead by example in your choice of words, especially having acknowledged that parties who have lost are understandably aggrieved. An aggrieved party may use inappropriate words out of anger, not justifiably because they can be sanctioned for that. But who then can punish the court, especially the highest court of the land, which has been said to be out of reproach for the fact that it is the last court? How do we punish the Supreme Court? when the Supreme Court employs language which we find inappropriate. Thank you.
Thank you, Council Owiti. I'm going to ask Dr. The bench overextends itself with its language.
Oh, of course, there are mechanisms for addressing misconduct by judges and magistrates, but I think we're jumping the gun. We're jumping the bridge before we reach there. We would have, first of all, to agree that the language adopted by the court was wrong, either as a matter of merit or as a matter of context or circumstances. When I listen to the paragraph my colleague is reading, my understanding of it is that, one, it is irrelevant because is equating conduct expected of counsel to the same conduct expected of judges. My understanding is that the role of counsel is purely adversarial. It is purely partisan. And the role of judges, in my understanding in our society, besides determining the dispute, the technical dispute before the judges, I began by saying that law is, or rather language is normative to the extent that language embodies certain values of what we consider appropriate or inappropriate behavior. Now, by law, judges are entitled to reprimand. These are not my words, they in the Advocates Act. They're entitled to reprimand counsel for misconduct. Judges are entitled to reprimand litigants for misconduct. I don't know how someone will be reprimanded in language that placates their fragile egos, if indeed of the facts they are wrong. Judges are entitled to punish persons who engage in behavior that is inappropriate. And in short, I'm trying to say judges are not just technical craftsmen and women who just are legal machines that get a decision ensuring it slots in the right hole and not. Judges actually also have a duty to protect the social values. I want to imagine we live in a society that has a social value that is repulsive to fraud. And if a party is clearly perpetuating a fraud before a court of law, and in this case, the apex court, then appropriate language must be used to show the indignation both to the court and to remind these parties, we are not going to encourage a system of justice in which people can, without blinking, come and lie in broad daylight and seek to obtain justice by false pretenses, if you ask me. And it must also be accepted that even the language itself is a form of punishment for these counsels. The court was well entitled to impose more severe. I hear my colleague talking of, there are mechanisms for dealing with errant advocates, there are mechanisms for dealing with errant litigants. I want to suggest even disapproving language that censure is itself a form of punishment to express or to convey the inappropriateness or the unacceptability, in my view, of the behavior that was in question. And I will say this point until the cows come home. Before you make the conclusion that the language was inappropriate, what was the context in which that language was used? Why did the court describe the case as a wild goose chase? It is because the litigants, first of all, come to court with fake documents. The court is graceful enough to indulge them with the scrutiny of the servers. The court is graceful enough to indulge them with the scrutiny of the ballot boxes. And you are making these wild allegations running into, you saw documents in a truck full of documents. And you're not able to prove a single allegation. After you have forced the court to pour through a truck full of documents, you have forced the court to engage in a scrutiny and recount across 4 counties. You have forced the court to engage in a scrutiny of the servers and whatnot. I just don't know what is a more perfect example of engaging the court in a wild goose chase if those are the facts of the case. And I keep reminding people, there is nothing pejorative about the phrase wild goose chase as a matter of English grammar. There is nothing pejorative about the phrase hot air as a simple matter of English grammar. So I do not know if the petitioners are feeling aggrieved with the outcome of the decision, then we can have a webinar to discuss the merits of the decision. But if the complaint by the petitioners and those who are sympathetic to their cause is that the court used inappropriate language, I am afraid that complaint is just itself hot air, to use the language of the court.
Thank you, Doctor. I'm going to go to Councillor Witi for a couple more minutes, and then we'll move on to the next question. If you'd like to respond to that, please.
Yes, thank you very much. First, I must say that I am neither a petitioner or sympathetic to the petitioner. I have read the judgment, like I said, and I agree with the findings of the court on the merits of the case. It was a properly straightforward and a directly straightforward case, and the court found it right on all the 9 issues from a reading thereof. However, in my view, that is. However, like I started by saying, the court has tools, appropriate tools. The court, as Menendez Senior has indicated, is expected to be impartial and not descend to the arena and fight with parties. The parties can have their fights, and the court is expected to remain impartial so that if there was such inappropriate language as between counsel, as we've seen in courts before, the court would come in and remind them that counsel, that is not language for the court. That is why we are expecting that for a referee to be able to stop people when they employ inappropriate languages, the referee itself must be on a high pedestal in terms of the choice of language. In response to what Senior says, that the court was entitled to employ the choice of words, I'm afraid I disagree. The law applies and provides the court with what it should do in every circumstance. For example, before we got this debate to this level, we've had it on social media. One of the arguments that Senior Mudombi makes is that what counsel for the petitioners did was an obstruction of justice, which I agree entirely. But Section 28 of the Supreme Court Act, if you may allow me to read again, says a person who willfully interrupts or obstructs the proceeding of the Supreme Court is guilty of contempt of court, and the court can punish for contempt. The court then has no choice of, instead of punishing for contempt, let's say, now that punishing you for contempt would be so serious, I want to engage you in strong language, which then does not just hurt the counsel before court, but hurts in a country where the elections led to a 7-point-something, 6-point-something difference, that the larger public interest, the ego or that counsel says should not be assuaged of the counsel. There's some ego of the public out there that feels that it is already enough to have lost. Why then do you then insult, in quotes? I'm not suggesting that what the court did was to insult, but the language was so strong that it could hurt. And you know, for you to be able to understand the repercussions of the language and why it has become a subject of much debate online, for example, is that you can only see it from those on the other side who say that they were hurt by the choice of word. A person who, with respect to Mwalimu again, a person who was on the winning side may not feel the pain that a loser in that election petition feels when they are again told that it was not enough for you to lose, but your counsel or the side you were on brought us hot air. And I still think, and I maintain, that the court still would have reached the merits of the case without using the choice of words that they prefer. And the merits of the case, I still hold in agreement with Senior that the case was properly merited on the basis of the facts and the evidence. But the court lost it on the language, and we can see that the court is aware that language is very important. That's why, ironically, they also cried about language employed by counsel.
Thank you, Council Owiti. We'll delve into the question of merits a bit more further down, but for now I'm going to hand over back to Julie, my co-moderator. Thank you.
What an interesting start to this webinar. I hope that all our panelists, the persons who are interacting with us online, you're putting in your questions in the chat section. The panelists will be happy to engage in a more interactive question and answer session at the appropriate time. So please put in your questions, tweet about it, talk about it. Let's make the sessions interactive so that you can also hear the divergent views coming across from all the Kenyans who are tuned in. So we're not going to move into a different conversation, but something that was very relevant in this particular presidential petition. So for those of us who are watching our screens on bated breath, we noted a split screen moment occurred, whereby 4 of the commissioners left the National Tallying Center and went to issue a separate statement at Serena Hotel. This then became the Serena Quartet, as commonly referred to out here in social media and also in common parlance. What was the implication of that moment for the IEBC? What governance issues came out? And we saw that play in even in the presidential petition itself. A lot of questions were raised about the credibility and legitimacy of the announcement that was made by a minority, as opposed to that would have been made by the majority. So in terms of governance processes, what is your take on the questions on IEBC's management, be it the chairperson commissioners dichotomy or also the chairperson commission and also secretariat issues? I'll invite Professor Ben Sihanya to give us his first take, and thereafter, Dr. Mudomi Thiankulu will give a rebuttal to that. Over to you, Professor Ben Sihanya. Professor, are you with us? All right, I think the very prominent professor is having a challenge with his technical devices, so I can give the first opportunity to our panelist who's here with us, Dr. Mudomi Thiankulu. What is your take on the issue of the boardroom rapture of IEBC?
It is, of course, a very unfortunate development that you would have.
Good afternoon. Good afternoon, participants. Yes, I was trying to. I was trying to speak, but there was a problem of. Now I'm being enabled, and that's okay. This is an important interaction, and more of this should be encouraged. I don't know how many minutes do I have to speak on this issue?
You have 10 minutes, Professor.
That's okay. Thank you. I want to appreciate the organizers of this webinar, as well as the participants.
So that we can see you as you speak to us.
Yes. Yes. Can you see me now?
Yes, we can.
So I appreciate this webinar, and straight on to the point, that I want to approach this question of governance concerns of IBC in the presidential election petition or the presidential election process, and including petition 2020. Using a three-pronged approach to the issues. Number one is that what is governance, what is management, and what is admin with respect to IEBC in presidential election petition and presidential elections 2022. Number two is that, or generally, that the number one is generally what is governance, what is management, and what is administration with respect to IEBC. Number two, what we understand by governance, management, what is the what we understand by IBC, what presidential there are too many echoes. And number three is the role of IBC in terms of governance management with respect to the presidential election petition. So briefly, there has been a lot of debate over the years regarding governance at IBC. This led to what was regarded as a compromise in terms of the role of IBC as a commission, the role of the chair, the role of the secretariat. And all of us know these have been debates in 2013, 2017, 12 presidential election petitions, and moving on into 2022. So the most important clauses here are, or authorities are Article 138, 3C to be precise, and Article 138, 10. And this relates to the role of the IBC as a commission vis-a-vis the role of IBC chair. And let me start by saying these issues of governance. Governance is, of course, a much broader term that includes questions of management and questions of administration. Administration can be the day-to-day running of the affairs of IBC, much as sometimes it can also be broader, and also management. But governance is now looking broadly into policy and related issues, and therefore, in terms of the governance of IBC, there has been a compromise that the commission, including commissioners as well as the chair, have a role in terms of policy formulation, strategy, and oversight. And then the secretariat, led by the CEO, is supposed to be responsible for the day-to-day administration, day-to-day management of the affairs. And that also comes to the question of in presidential elections, that there are certain boundaries, so that, for instance, matters procurement are largely management. But then there should be a role of the commission and the chair in terms of governance to make sure that they are done properly. And of course, this was one of the most important problems, that procurement, Smartmatic, it was well known as a rogue election technology supplier. It was well known. And when there was the TV interview, it was clear that both the chair and the CEO did not want to commit on having had prior information that this was a rogue provider which had messed up many countries in terms of elections. So then how do we explain the decision of the Supreme Court on these issues? It is clear as daylight that the Supreme Court was aware of the problems at IEBC with respect to the presidential election 2022. Why do I say so? Number one, both in the petition as well as in the affidavits and also argumentation submissions, there was clear evidence that the commission chair acted on his own on many matters. And during the argumentation, actually some of the judges even said, the Chief Justice herself said that it did appear that the other commissioners were being given domestic roles. And many other judges pointed out that during the argumentation. It is quite intriguing because I've heard Dr. Mudomi Tiankolu consistently in this debate and in elsewhere saying that there were forgeries, nothing was proved. But Dr. Tiankolu and even the courts do not say what these forgeries were and what was not proved on this. During argumentation, the judges were very, very clear that the roles that had been given to the commissioners was not consistent with the constitutional provisions, was not consistent with the statute law, with the regulations, with administrative and management processes, with the role in terms of corporate governance. And with the previous decisions of the Supreme Court itself, including in Raila 2017, it was very clear that the commissioners were being given inferior roles, such as receiving guests and stuff like that, while Chebukati as chair and with his favored commissioners and with the CEO were the ones now dealing with the results directly. So what other evidence did Dr. Mutemi Tiankolu, did the Supreme Court want when it was already, the court could even take judicial notice of that because these things were live on TV. The second major point there is this. So after the Supreme Court also made those observations during argumentation, the next point was that Article 138(3)(c) talks about tallying, verification, and declaration. And the commission as commission or qua commission, QUA, has a role in that. There's also 138(10), where now it's the chair, and the language is declaration, which means declaration is the administrative aspect of declaration. The chair will do it at the tail end. The executive major decision making on tallying, verification, and declaration is to be done by the commission as commission. And there is enough case law in this country, including Raila 2017, Maina Kiai, which we prosecuted from the High Court through Court of Appeal and the Supreme Court, which are clear that the chair is not the commission. When you talk about the commission, is the commission acting collectively and in an executive role. Executive not in the way we think of the president, etc., but in terms of they have to exercise their minds to the process. It's not just an ordinary matter of pushing paper. They have to exercise their minds on this. And therefore, to the extent that the judges had found during argumentation that the commissioners were not involved in some of these processes, to that extent, the decision cannot stand, the final decision. The last point on this is that the court did not address its mind. Of course, at the end of the day, they said, oh, the commissioners had been participating, the 4 commissioners, the majority, and by the way, this is majority. They had been participating in announcement, they had been participating in these processes, and that is only at the tail end that they did not own the process. And that's okay. Why do I say so? Number one, if you read Articles 138(3)(c), 138(10), you read it with the IBC Act, and also you read it with the schedule, and you will see that there is a clear indication that the commission ought to decide matters. They can decide unanimously or by what is called by consensus, or in the event there is no consensus, they decide on by the majority. And therefore, majority can say, no, we don't buy this. And this is precisely what happened. That the final declaration of who the winner is itself a separate decision from the announcement of respective constituency results. The decision to announce respective constituency results is different, because you can agree that these constituency results are okay, but you may still say, no, we have 50% plus 1 has not been reached, 24 constituencies, 25% in 24 constituencies has not been attained, etc., etc. So that are different decisions. So this is incoherent decision by the Supreme Court. It cannot be assumed that if you have approved the release of some constituency results, then you have also approved the final declaration of who the winner is. And the Supreme Court, in the determination, did not address the question of 27 constituencies, which had not been announced, let alone fully declared. They had not been tallied, they had not been verified, etc. So even if assuming, and that is wrong, it's wrong to assume that the 4 commissioners had always been going along on all the decisions, then what about the 27 constituencies which had not been declared? So the decision of the Supreme Court is not coherent, internally coherent, both the determination as well as the final decision, because if you read the two, even in the final one, there is less hot air, and the hot air to be used by a Supreme Court, a court that had told us, all of us, to use proper language, to relate with respect, a court that ought to say, we find that there is no probative evidence, but not to go hot air, sensational, and such alarmist language. Most of the judges in that bench actually have cautioned advocates not to use questions that, because the incoherence and with the decisions of previous decisions of the Supreme Court on presidential election petitions 2017 ×2, as well as the decision in Mutharika in Malawi, which applied the Kenyan decision. Thank you.
For your sentiments on the same, I want to invite Dr. Muthomi Thiankolo to give his rebuttal, but also address himself to the matter, so that it's not only a rebuttal to you, but also your 2 cents around the question of the IEBC boardroom rapture.
Yes, but Prof has also drifted into the issue of the language. And I would be interested, because we are discussing a legal matter, the way our legal system works is that it's not enough for you to say the court is wrong or I'm unhappy with this. Our system is one called common law system. I'll be interested to hear which section in the thousands of the chapters of the laws of Kenya forbids the court from using the word author, that forbids the court from describing the exercises and motions it was taken through as a wild goose chase. I'll be interested to hear a decision, a precedent, from either our courts or from the Commonwealth, or indeed from anywhere in the world, that says if litigants and their lawyers engage in fraudulent tactics in litigation, the court cannot use strong language to express its disapproval of that type of behavior. If we go to the issue about the IBC and the issue of the 4 commissioners, my starting point is that as the court found, the fact that there will be such dramatic behavior from the IBC commissioners at such a critical moment is a symptom of what the court called the governance malaise within the institution. And for me, it brings to focus whether we are honest as a society when we even label an institution like that as an independent electoral and boundaries commission. Are the people appointed to such a commission actually themselves independent, or do they see themselves as gatekeepers of various partisan players in the electoral process? Because I want to imagine the IBC commissioners, if they were to stick true to their mandate, have no interest in who is declared the winner of an election. It is no business of any IBC commissioner to be concerned with who wins or who loses. Their duty is to provide appropriate structures for the people to express their will. And while that will is expressed, the individual preferences of the commissioners have no place, not as a matter of law, not as a matter of principle. So I do not therefore understand in what context 4 commissioners of the electoral management body would come and become petitioners, because although they were cited as respondents, their behavior all through and through was that of a partisan player in the election agitating for a certain preferred partisan outcome. To me, it is a breach of the oath of office amongst those commissioners. To that issue, which I don't think many people understand, to me, personally, my view is that the fact that there are divisions within the IBC is nothing major, because I would actually be surprised that there is a body with 7 commissioners and they agree all the time. Even in our courts, we have divisions. That's why you find dissenting opinions and whatnot. The problem I had with the behavior of the 4 commissioners is not that they disagreed with the chair and the other 3 commissioners, because that is allowed. What I had problems with is the legal consequence they were inviting the court to impose on those divisions, because their position, if I understood it, was that the result of an election is a matter for a decision by the commissioners in plenary. Yet my own understanding of the law, the question of who is elected president of Kenya, or indeed any other elected position, is not a matter for the decision of the commission. It is a matter for the decision of the voters, and that decision was made in 46,229 polling stations. The idea that therefore, if a majority of the commissioners don't approve of that result, first of all, they were arrogating to themselves a non-existent legal power to approve the outcome. The outcome of the election was as declared in each of the 46 plus polling stations. There is this myth they were also selling that, they were giving the impression that whatever happens at the National Tallying Center is what constitutes tallying and verification and declaration of the results. The truth of the matter is that the Constitution itself says all those exercises shall happen at the polling station. In fact, at the polling station, we have an individual tally sheet for every candidate. That is the first point. After the counting, there is a tallying there. The whole question of declaration of results, the results are also declared at the polling station, and there is no commissioner present usually in those 46,000 polling stations, and it is declared in a document, an official certificate called Form 34A. There is a further collation. I think what a lot of people don't know, what happens actually at the National Tallying Center is not tallying and whatnot, it's collation. It is a purely arithmetic exercise, an exercise in the nature of what was the sum total addition, what was the sum of the votes governed by the respective candidates in all the polling stations. The answer to that question is an arithmetic consequence. It is not a matter for the opinion or decision or discretion of the commissioners. And I want to very boldly suggest that even if it were true, it is not true on the facts of the case, even if it were true that the chairman of the IBC completely excluded all the commissioners, that would of course be illegal, that would of course be irregular, but it would not lead to a nullification of that election if the will of the voters can be ascertained through an arithmetic exercise, which is about adding the results gotten in polling station number 1, number 2, up to the polling station number 46,229. So in my view, I don't know who lied to these commissioners. And there is a further reason why, speaking for myself, and I think even for the client I represented, if the position of the 4 commissioners were to be taken to its logical extreme, it would mean Kenyans would vote a particular candidate, but the commissioners could veto and say, never mind, this is what the arithmetic, the addition gives us. The position of the majority of the commissioners is the other candidate won. So then for me, and why that is dangerous, it would mean then if you're a presidential candidate or whatever other candidate, the person you need to persuade to get that office is not the Kenyan voters, it is a majority of the IBC commissioners. So their case, in my view, was a subversion of the law. If it was not a subversion of the law, it was a grave misapprehension of the law. And if they had misapprehended the law, that fundamentally it raises serious questions, whether they're actually competent to occupy an office of that nature. When all is said and done, the sort of unnecessary melodrama we saw with that institution, and it seems to be a jinxed institution, is something we need to reflect upon. And I don't think it's a question we'll resolve through a legal debate. It's a question of, do Kenyans actually believe in free and fair elections? Do Kenyans believe that IBC commissioners should actually be free and independent and not beholden to any political formation or any political candidate and whatnot? These are fundamental questions we need to be asking about our democracy, because in my view, what was happening at IEBC is just a reflection of the type of people we are, the type of values we espouse, especially on the question of whether we actually believe in free, fair, and transparent elections, or are we happy to tweak the election if we can, and it suits our preferred candidate, then that's the type of democracy we want. That's all for now.
Thank you very much, Professor Sihanya and Dr. Muthomi, for those introductory remarks. I will allow Professor Sihanya a right of rebuttal.
Yes. How many minutes?
I'll give you 2 minutes.
Give me 3. For 3
It's
points.
okay. No problem, Prof.
Number 1 is that Dr. Muthomi Thiankolu is lucky that he can speak without any authority. I don't have that luxury, and he has not cited any authority at all whatsoever. In fact, he has gone to amend the constitution. So, and these are serious issues. So let me start. And also he can talk about, so number 1 is, for example, he talks about fraudulent, forged. That is quite emotional and sensational language. He has neither Dr. Thiankolu nor the Supreme Court justices have indicated what they are calling forged documents. It's rhetoric, and we are aware of rhetoric. In fact, rhetoric was a professorial chair in Oxford and Cambridge for a long time. But rhetoric must be based on some evidence, some law, and some analysis. What are these fraudulent documents you are talking about? What are these forgeries? You don't just make a claim. We don't make claims like that to suit a predetermined decision. What are these? So that's number 1. So it's based on hot air. Those arguments are based on hot air, as it were. It's a wild goose chase to tell us there were fraudulent or forged documents when there is no evidence of them being fraudulent or forged. Number 2 is the question of what I would call the amendment of the Constitution by Dr. Thiankolu this afternoon, and probably even by the Supreme Court, and an constitutional amendment to the Constitution. He's consistently said that decisions on who the president is have already been made at the 46,000 polling stations. The declarations have been made there. That what is being done at Bomas is collation, not tallying. Dr. Thiankolu, Article 138, 3C, open it now. There is no word called collation. There's the words called tallying, verification, and declaration. And the Joho case and so many Supreme Court cases have defined some of those terms, like the difference between declaration and announcement. What is being done, and I was one of the architects of Maina Kiai, High Court to Supreme Court. What is being done on presidential elections at polling station is announcing who the votes. They are not declaring who has won the presidency in the polling station. It's as simple as that. That is Con Law 101. So if it were to be declared the president at the polling station, it would mean that we would probably have 46,000 presidents, or in this one wins in this, one wins in that. So who is the president? Declaration of who the president is not done, please, at the polling station. No. Declaration is done after tallying, verification, and the declaration is at the final level, please. Then there is also this statement that, and the word collation is not there in 138. And for us also on these issues of whether Kenyans want free and fair elections, yes, Kenyans want. And that's why Article 1, Article 38, political rights, Article 1, sovereignty, Article 38, political rights, Article 81, 86, free and fair elections, credible, etc., with these issues of tallying are there in the Constitution. So Kenyans have decided they want it. But IEBC is being used by Kamago and beneficiaries of Kamago to frustrate that. There's no doubt, there's no equivocation, ambiguity, or ambivalence on whether Kenyans in their masses want free and fair elections. The last point for me is also corporate law and Con Law 101, which is the first day of law school. IEBC is a body corporate. It's a commission. It's a Chapter 15 commission. Articles 248, 50, etc., etc. There's so many clauses. It ought to make decisions collectively as a commission, as I said earlier. And the commission means commissioners and the chair. And then, of course, the management led by the CEO. Corporate law and Con Law 101 say that if there is a problem in the management, in governance, in administration, in decision-making of a corporate body, you can lift the veil. And that's the case of Solomon versus Solomon. And so many, Supreme Court has also said so many times that the fact that you are an independent commission does not mean that we cannot lift the veil and see who is making what decisions. So the veil can always be lifted, and the irrespective commissioners are not bound to be led to the slaughterhouse, be led to make Kamago-like decisions by a compromised IEBC Chebukati. Supreme Court 2017 found that the commission had done wrong, and actually Chebukati and the commission had refused and failed to even to open the server. And these are issues which have been there, and it was in contempt. So please, Corporate Law 101 says that commissioners don't have to have been interested in being joined as a respondent, or would have agreed to be an interested party, except that in some of these petitions, the court rarely allows interested parties. So I think let's just agree that if we claim that there is fraudulence, if you claim that forged, these are very emotional and emotive words, we must state so. And I'm sorry if I'm coming out too strongly, because I think the work that was done here was quite heavy, and you cannot just sit back and hear individuals say it is fraudulent without evidence. And also amend the constitution on the question of tallying to be replaced by collation and declaration to be taken to the polling station instead of national level. And that's what I would say for now. Thank you.
Thank you very much, Professor Sihanya. I have been cued that Dr. Muthomi has a rebuttal for your rebuttal.
Yes, Julie, that I'm just using hyperbole when I talk about forgeries. On the record, the petitioners presented a document that they pretended were logs evidencing that Jose Camargo and other foreigners and other local players were intercepting the results and changing them before they are posted on the IBC portal. It is beyond argument that it was demonstrated that one, those logs were the same logs that had been used in 2017. The logs of 2017 cannot possibly be evidence of hacking in 2022. That was demonstrated beyond argument to the court. Number two, those logs of 2017, which the petitioners were purporting to present as evidence of infiltration of the system, had been falsified. In fact, the reason they were caught is they had changed the dates in all those lines from 2017 to 2022. But because, unfortunately, this is what happens when you're lying, they forgot to amend some of the lines and the dates remained written 2017. That was outright forgery. The court confirmed it was outright forgery. It's not me saying it from the bar. The court actually confirmed that that document was forged. Two of the petitioner's witnesses, I was only avoiding the merits of this matter because I don't want to discuss professional colleagues in a forum like this, but in summary, two of the petitioner's advocates saw affidavits to which they attached purported forms 34A, which had been tinkered with, and they said these forms were forms given to the petitioner's agents in various polling stations, and they were inconsistent with the genuine forms. The petitioner's own agent, now not the respondents, an agent of the petitioner saw an affidavit saying, no, that is not true. That form that advocate has attached to his affidavit is not the form I was given by the presiding officer. But more importantly, the presiding officers themselves came in their numbers. And they said, we don't know where the advocates got these versions of the documents they claim they were given by agents. Those documents are forgeries. And therefore, again, it is not me who is alleging or using hot air to say that there were forgeries. The court record, the judgment confirms what I'm saying is exactly what happened. We saw in live court, all of us, something that was described as a live demonstration of the man in the middle, baptized Jose Camago. And then it turned out that one, it was not evidence of a man in the middle. All that the advocate was trying to do was to misrepresent the fact that a Form 34A had been scanned while it was on top of an envelope that had been used to wrap the physical copies of the register and other election materials. And it was common ground that every polling station had those envelopes, clearly written Jose Camago. An advocate pretends in open court that this document is the evidence that there was a foreigner called Jose Camago who was intercepting the results. The petitioners brought a report. There was actually two reports by supposed document examiners and experts who are to vouch for the documents, the forged documents that their two advocates were presenting. And one of the issues that arose is, it is elementary knowledge that if you're a serious document examiner, you will not express an opinion on the genuineness of a photocopy unless you have compared it with the original. They had not done that, and therefore their opinion fell flat. The DCI himself came with a report called the forensic imaging of a laptop that he claimed that this is the laptop one of the respondents was using to do these things they had copied and pasted, by the way, from Donald Trump's petition in the United States called dumping, staging, and whatnot. And in short, the DCI through this report was saying, we have done a forensic review of this laptop. We have found these are the web addresses of the server to which the results were being staged and dumped and whatnot. And it turned out that, first of all, there was nothing like that in the laptop. And number two, the addresses they were talking about were non-existent. And number three, some of the platforms were actually platforms that anyone, like there was one called MyShare or something like that, actually sold by Microsoft to anyone on subscription. Any one of us can go to Microsoft and subscribe to that platform. I could go on and on, Julie, but I want to correct Professor Sienya by saying, when we say that the petitioners were relying on forgeries on top of forgeries and fraud upon fraud, it is not a claim we are making just for purposes of the debate. It is confirmed by the judgment of the court. It is confirmed by the scrutiny and recount exercise. What I have found interesting, and this is the last point I want to say on this. I told you Kenya has 46,229 polling stations. In all these cases we are calling hot air and wild goose chase, all the 9 petitioners were unable to point one polling station out of 46,229 in which the result was different. I'm mentioning one out of 46,000. They could not identify even one in which the result had been fraudulently altered to the benefit of the respondent. And clearly then it has to be hot air. I just don't see how else we would describe it.
All right. Interesting perspectives, very divergent in that matter. I will allow us to move on from this particular topic, but I know that we will discuss it again when we go into plenary, because I think the governance questions of IEBC played out quite significantly at the Supreme Court. And I know even the Supreme Court went ahead to give recommendations for proposals in order to reform the institution, which I will invite then the panelists at that time to discuss around their veracity and how we can actually implement that. Because as we move into 2027, the decision of the court will guide the reform process. So how do we then move on to ensure that IEBC is well kitted for the 2027 election? I'll hand over back to Valentine Haminu to guide us through the next set of questions. Thank you.
Thank you, Julie. Interestingly, in Supreme Court election petitions, the standard of proof is pegged in a murky space between the general criminal standard of beyond reasonable doubt and the general civil standard of a balance of probabilities. With so much at stake, please give us your views on the efficacy of this murky standard of proof, bearing in mind the interplay and reliance on election technology, information technology. Ideally, technology is supposed to facilitate voting. So I'm going to ask our next speaker, Senior Luciana Thuo, who's a lecturer, to give us her views on this question, please. Thank you.
Thank you, Valentine. I hope you can hear me clearly. Okay.
Sorry, I beg your pardon. Did you hear me?
Yes, I did. Can you hear me clearly?
Yes, we can hear you.
Thank you. I have been asked to speak to the question of standard of proof, but allow me to start with just contextualizing this question of standard of proof by just talking about evidentiary issues broadly before we talk about standard of proof and how it relates to technology. When we talk about proof and election petition, there's two things that distinguish. There is who bears the burden of proving it, and then to what extent must they prove their allegations that in an election petition. So we talk about the legal burden, and we also talk about the evidentiary burden. So let's start with the legal burden, which is who must prove that who bears the obligation of proving their case in an election proceeding, and that usually rests with the petition. The evidentiary burden is, as the court has described in 2019 and 2017, a shifting burden. And it starts with the petitioner because it's the petitioner who is convincing the court that they should overturn an election law. But the court has indicated that depending on the extent to which that evidentiary burden is discharged by the petitioner, then it would shift to the respondent and it would keep shifting throughout the trial, so that the court can establish whether the allegations have been proved or disproved at the end of the proceeding. So the legal burden doesn't shift, the evidentiary burden shifts. Ideally, from the reading of the jurisprudence of the court from 2013, 2017, 2022, that issue is not contentious. What becomes contentious is the standard of proof. And if you read through the jurisprudence from 2013, when the court established what you're calling the intermediate standard, the court was studying two things, and it's at the same thing that was brought about in 2022. On one hand, you don't want to discourage litigants from ventilating political activity what election issues are. But on the other hand, you have a proceeding which is not an ordinary proceeding. It's what we call a sui generis proceeding. And therefore, there is a question as to whether we should apply the same standards that we apply in civil proceedings to election petitions. So in 2013 to 2017, the court was asked to find that the test is what is applied in other jurisdictions. So in England, in Malawi, we employ the balance of probability. The balance of probability would simply require you to prove whether the events that you're alleging are more likely than not to have occurred. And the argument that is made there is that an election petition is just like any other constitutional dispute. What is at play is whether there was compliance with the Constitution. And if that is the case, then there is no rationale for requiring a higher standard that you would require for any other constitutional litigation issue. But the flip side, which is the position that has been taken by the court, is that whereas it is true we should not discourage litigants from making claims to the court by setting higher thresholds for election petitions than for any other proceeding, we must also acknowledge the public interest nature in hearing the petition. And therefore, we must require them to prove beyond what they would require in an ordinary legal proceeding. And that is where we create this intermediate standard between are these events likely to have more likely than not to have occurred, which is the balance of probability, and the standard which we use in criminal trials, which is beyond reasonable doubt. So what we see in election petitions, going by what the court has said that these are sui-generis proceedings, is twofold. Depending on what you're alleging, the standard is different. If you're electing on compliance with the Constitution and the procedure for the conduct of election, then you're required to prove it using that intermediate standard, and I'll come back to that. But if what you're alleging is either that there was criminality or an electoral malpractice that occurred, or that a specific element of the election, for example, did someone reach the threshold under Article 138(4)(a) to warrant and be declared the president-elect, the court has insisted in those two instances that the standard is beyond reasonable doubt. I'll take the second element, which is the more problematic one, and this is what both the Law Society and the ICJ as amicus were asking the court to revisit. There is a development that occurred in 2016 that appears to have not been captured in the jurisprudence of the court either in 2017 or 2022, which is the fact that when we're dealing with election offences in the context of an election petition, there appears to be a standard that has been declared by the courts, which is not consonant with the law. And here I'm referring to Section 87 of the Elections Act. And I'll give a brief historical antecedent to this dilemma, and I'm sure that he will speak more to it when he has the floor. Stemming back from 2013, when we had the Moses rectangular case, where we had allegations of bribery alongside other allegations in the Bungoma senatorial election, there was a finding that Moses rectangular had committed acts of bribery, and on the basis of that finding, then the election was managed. And the appeal went all the way to the Supreme Court, and the question that kept coming up from a reading of Section 87 was whether that standard of reasonable doubt was an appropriate standard in an election petition. Because a reading of Section 87 of the Elections Act presupposes that the election petition is a precursor to a subsequent criminal proceeding where whether in fact those acts were committed, it will be investigated and prosecuted. So reading from the concurring opinion of Rawan in 2013, there was a belief that the standard as was in the law in 2015 was that it was creating a trial within a trial. A petitioner, a respondent against whom election offences was alleged would then have to defend himself both in an election petition in a court-like criminal proceeding and would also be subjected to a subsequent criminal proceeding. So the question became, if there was a subsequent criminal proceeding, why would we need to prove election offences in an election petition beyond reasonable doubt? It was hoped that that direction would be given by the Supreme Court in 2017. It wasn't. And again, in 2022, that issue came before the court with LSA and amicus and ICJ. They invited the court to revisit that question. The idea being the law has changed in 2016, whereas the enforcement in the election court would make a determinative finding as to whether an election offence had occurred. As of 2016, the election court only makes a finding as to whether an offence may have occurred, and then invites the Directorate of Public Prosecution to carry out further investigation and determine whether they should actually prosecute the person who may or may not have committed those. So in light of the change in legislation that occurred in 2016, do we still need to retain the standard of proof for election offences as beyond reasonable doubt? It is believed that that standard is too high, given the fact that the election court is not making a determination as to the commission, it's making a factual finding as to whether there may or may not have been an election offence. And that is one of the things that the Supreme Court was being invited to revisit. But unfortunately, the one paragraph that was dedicated to that assessment did not delve into that question. But I'm sure that we will speak to that question in a moment. You asked me also to speak to the question of technology, and I know there will be a lot of discussion around that. So let's start by framing the place of technology in the elections that we do use that, because I think the petition makes a lot of premium on technology, particularly in the management of the law. And that does not take cognizance of the fact that voting in this country is manual. For the most part, what we do in an election is manual, but the law requires a complementary mechanism that will allow for voter identification, voter registration, voter identification, and then at the close of voting, electronic transmission of result back for the presidential election voting. So going by the jurisprudence of minor care in 2017, we know that the law requires the existence of a complementary mechanism, both an electronic mechanism for both identification, registration, identification, and then translation of results, but we also have a manual system. And the reason why the manual system is important is because there are instances where the technology fails, and as it was in 2022, there were about 235 polling stations where the biometric voter registration did not work. So what happens in instances where the technology fails, which as the court has said repeatedly since 2013, technology is prone to failure. The law does not give us the dark as to what we should do with it, and this has been mitigated as recently as the eve of the election. If this system that has been put together with the implementary system for identification and transmission of the law failed, the court has given direction in the Buddha versus KSRC case delivered on the eve of the election that there is a threefold process that will be followed. First, we are starting with the voting states and try to identify voters that fail. If that does not work, then we go from alphanumeric part of the voter on that case. And if that fails altogether, then we have manual identification of voters. The presiding officer will have to fill a form 32A as an accountability measure to make sure that no one who is identified manually is not accounted. But more importantly, the only result that we transmit is, of course, the presidential election. But we transmit in the case what has been declared at the polling station, because the court was clear in minor care. The locus of the free expression of the will of the voter is at the polling station. So if you want to improve an election on the basis of transmission of the results, you must be able to demonstrate that the results are declared at the polling station using a form 34A is different from the result that was transmitted using the case, and it is or different from the result that was brought to the national tallying center. If you are not able to ensure the result in the form 34A, even where there are challenges with the technology, whether it's transmission or otherwise, the results are declared at the polling station to be staff. That was the position in minor care that was restated by the court's revival in 2020. So, what were the issues that came out around technology in the 2023 petition? Issue number one was around the audit of the voter register. By virtue of the introduction of biometric voter registration, we now have a manual register and we have a biometric voters register under section 6A of the election act. There were questions as to the timing of the audit of that register and whether it was done sufficiently to deal with the issue well in time for the IBC to deal with the issue raised by the auditor, and particularly because, as we heard in the media, there were erroneous mass transfer of voters from one polling station to another without their consent. So there were questions as to whether the audit of the register had been done completely, and whether there would be enough time for the connections to the issue raised by the police and the to be addressed before the election. Some petitioners questioned the fact that the audit was done too late to the day that even when the report was posted on the IBC website, there was not enough time for meaningful engagement with the voters. They have also been concerned as to whether there was actually a proper audit of the biometric voter register. But I will leave that because I'm not an expert. Second issue that came up was what was the impact of the failure of the case. So we had in some instances that there was some limitations that the judgment report at least 235 where the case is failed. One of the arguments that was made was that there was a link between the failure of the case and voter suppression, that people in those polling stations were not able to cast a ballot because they went away and the case is failed. I will let that speak to that question of voter suppression, but the argument there is that there is a link between people, the low number turnout of voters in those areas where the case is failed and the failure of the case. That question turned around the results transmission system. There were questions as to whether there were unauthorized persons who had access to the results transmission system. We tried referring to Kabarak who was mentioned several throughout the petition. So what the court was called to determine in the context of the petition was whether this results transmission system that was used by the IBC complied with the standard both in section 44 and article 86, which are requirements of simplicity, accuracy, verifiability, security, accountability, and transparency. And so the petitioner, going back to the question of standard of proof, had to be able to demonstrate to the court beyond the balance of probability that there were people who had unauthorized access to the services, who then had the capacity to interfere with the result as per the. I will allow that me to speak to those issues as they related to the election position.
Counsel Dudley Ochel to please give us his views on the standard of proof and to also speak on the issues of election technology. Thank you.
Thank you, Valentine. Thank you, Luciana. Let me start from Raila 2013. The court says that the standard of proof is intermediate and that if you are alleging electoral offenses, then you must prove it beyond reasonable doubt. The court was right in Raila 2013 because Section 87 of the Elections Act required the court to determine the persons who have been proved guilty. When you want to make a determination of guilt, then you prove it beyond reasonable doubt because it has criminal consequences. But then during that circle, something else happened. Someone was proved guilty of the offense of voter bribery. And that is the current Speaker of the National Assembly, Moses Wetangula. And his case went all the way to the Supreme Court. There was an allegation that he'd given some 260,000 to Friends Church Kandui. I think that must be someplace close to my friend Ongoya's home. 260,000 to pastors and whatever. And it was proved that that was a bribe. And so this case rises all the way to the Supreme Court. And the Supreme Court sees the difficulty in trying criminal offenses within the election petition process. And Rawal specifically writes a separate concurrent opinion where she says that when you conduct the trial twice, you first prove someone guilty within the election petition process, and then you also prove them guilty within the subsequent trial at the magistrate's court, then there are fair trial concerns. And so they ordered those two jurisdictions to be separated. So the court, first of all, deals with the petition, and then the electoral offenses are dealt with later. That change came in 2016. Parliament, during the Orengo Kiraitu bipartisan processes, amended Section 87 by first amended the Elections Act by removing all offenses from it, except the offense of double registration as a voter. Now, that's not the kind of offense you'll find pleaded in a petition, but all the other offenses, they sent to the Elections Offences Act, where the DPP now has 2 years to prosecute election offenses. It also then changed the language of Section 87, as Luciana has spoken. Section 87 now requires the court, and Section 87 currently requires the court to demonstrate if an offense may have occurred. I'm projecting Section 87 on my screen. An election court may, at the conclusion of the hearing of a petition, in addition to any other orders, make a determination on whether a malpractice of a criminal nature may have occurred. Now, in 2017, the court was asked to depart from the intermediate standard, but Section 87 was not cited to it. The court sustained the 2013 standard and says that electoral offenses will be proved to an intermediate standard, but if you allege criminal offenses, then you must prove it beyond reasonable doubt. This year, the court was now expressly informed that it needed to attune the standard of proof to Section 87 because the law had changed. And the two amici curiae, the ICJ and LSK, also told the court that the jurisdictions which use proof beyond reasonable doubt have fused the two jurisdictions. The election petition court can find you guilty. That's Section 99 of the Indian statute. I've seen my friend Gautam Omondi Bhatia. Section 99 of the Indian statute uses the word guilty, like our Section 87 did in 2013. Section 158 of the UK statute also has a finding of guilt. And that is the same case for Section 20 of the Ghanaian statute, which uses the word guilty. A Commonwealth jurisdiction, Mauritius, has observed the need that has noted the material difference between Mauritius and the United Kingdom, saying that they will use the civil standard because of the material difference in the legislation in those two jurisdictions. But so what does the Supreme Court of Kenya say about the standard of proof? It says that because we've said twice that the standard of proof is intermediate, we will maintain it at that level. It does not mention Section 87 and its impact on the standard of proof. It does not say what the utility of that heightened standard of proof would be. In fact, when referring to the allegation of electoral offenses, it says that because you are alleging electoral offenses, then you must prove these beyond reasonable doubt. It doesn't, but it cites Section 87 in its judgment, but does not interpret it. It leaves me with some questions in my mind. One, why would the Supreme Court order a separation of the two jurisdictions if it makes no difference? And why would Parliament change the language of a statute from determine the persons proved guilty to determine if an electoral offense may have occurred without a change in meaning? How can those two phrases be the same? We are told that Parliament does not waste words. And then also takes me back to the rectangular issue. If someone has been proved beyond reasonable doubt within a petition to have committed an electoral offense, then what will the magistrate court do except convict and sentence? And if that is the case, then what happens to the autrefois convict principle? You shall not be convicted twice for the same offense over the same facts, the double jeopardy rule. And if the Supreme Court can requires proof beyond reasonable doubt, then why won't the court just go ahead and sentence? Because the crime has been established before the Supreme Court beyond reasonable doubt. And also, and that would lead me to the issue of timelines. The court has 14 days. 7 days are spent in the pretrial processes, the filing of the petition, the responses to it, the interlocutory appeal. So the court has about 3 days to hear the main petition. Now, a petitioner has one of those 3 days. The first day can be given to the petitioner, second respondents, and then rejoinder on the third. So the petitioner has 1 day to prove beyond reasonable doubt the same thing that the DPP under the Election Offences Act, using state resources and equipped with counsel in the rank of my friend Victor Witty, well-experienced counsel of all cadres, 2 years to demonstrate, 2 years to prove that a criminal offense occurred beyond reasonable doubt, the same thing that a petitioner has 1 day using affidavit evidence to demonstrate. I think, in short, the Supreme Court should also have just gone ahead and reversed the 2017 distinction between qualitative and quantitative elements and say that, we found it's too easy to overturn presidential election petitions. We think the threshold should be higher. And so you must also demonstrate the violations and the effect of the violations, and you must demonstrate beyond reasonable doubt. The Supreme Court, in other words, is saying that do not dare to allege a criminal offense, whether it's voter intimidation under the Constitution, whether it's voter bribery, whether it's corruption. Do not try to plead anything in the nature of a criminal offense in an election petition, otherwise you're bound to lose it. On the issue of timelines, I think there's consensus that the 14 days are inadequate and that we could try to change the timelines. Maybe Uganda's 30 days. On the extreme end, we have Nigeria's 180 days. But the problem with Nigeria is that initially there was no timeline at all. But then the president-elect assumes office. So you're litigating the case for 5 years when the president-elect is in office. I think he is sworn in and becomes the president. He's not referred to as the president-elect. But now they have 180 days in their law. Uganda has 30 days, and Kenya's 14 days seem to be motivated by a good ideal to ensure that time does not run out when you're still in court litigating the issue. But 14 days seems to be inadequate. There's consensus. I've been on both sides. I've been on the side of a petitioner, just assisting technically. I've been in a main petitioner's camp, and the timing is inadequate from that side. I've also represented amicus. I represented ICJ as amicus, and that time is still inadequate because you have some time. I think you have 4 days from the date the petition is filed. This time we had about 9 petitions. And that brings me to my closing point. You'll allow me to digress just a little bit, use a minute for it. Mudhomi Thiankolu wondered what law requires courts to use appropriate language. That law, first, is the Judicial Service Code of Conduct. It requires judicial officers to maintain propriety and to treat the public with courtesy and respect. That demands for appropriate language. Then when you also go to the Judicial Service Act proper, the first schedule, section 13, on the criteria for selection of judicial officers, then you also use for potential candidates who use courteous language and who have integrity, which includes the need to maintain propriety and the appearance of propriety. I think we've had an extreme case of judicial anger in 2016. You remember that time when there was an issue of when should Supreme Court, the first set of Supreme Court judges should retire. And there was one extremely angry judge. Now, when you are angry, then it leads first to the danger of shallow processes in thought. You're likely to make quick conclusions that confirm the anger. You're also likely to reach premature decisions and then to overbleed that anger. I think the example is apparent. We've heard my friend, Mr. Thiankolu, say repeatedly, the petitioners. Well, there were about 8 petitions. But when he say, he doesn't, try to distinguish between the 5th and other petitioners, and from the 1st to 4th petitioners and the rest of the petitioners, they're lumped together. That happens when courts become angry in the nature that we were discussing. Thank you, I'll rest at that point. Thank you.
Councillor Chell, for those views. Now, before we move on to the next question, I'm just going to ask Ms. Thuo to respond or to add any additional views that she has on the question, please. And just a reminder to our many viewers, a special thank you, particularly to the viewers at Kabarak University. I'm told there's over 300. You can post your questions in the comments box, and we shall field them with the panelists towards the end of the discussion. Thank you, Ms. Thuo.
Thank you, Valentine. I hope you can still hear me. And the team at the ICB.
Yes, we can hear you well. Thank you.
Thank you. I just want to add on to something that Bradley has said about the impact of Section 87. And I think it is important to think about the Supreme Court role, particularly in light of Article 167. That this jurisprudence that is set by the Supreme Court is not just binding on it doesn't bind the Supreme Court, but it's binding on all other courts that come below. When you think about, when we talk about why we feel the court should have pronounced itself on the impact of the change of the law in 2016, it's because by virtue of Article 163(7) of the Constitution, all other courts which are faced with similar situations are bound to apply the same principles. I argue, and I know this will come up in existing cases at other courts, that Section 87 presupposes there will be some other proceeding. But there are instances, and one instance has presented itself, where you have an election petition being filed, and simultaneously the person is also charged in a criminal trial. So when this person is appearing in the election petition, what standard should the court be using in that case? And especially because in the petition, one of the issues raised then is fair trial questions, given that the proceedings in the criminal matter are the same things that are being used in the election petition. So the questions we are raising around Section 87 are not idle. They were worthy of determination by the Supreme Court in light of the impact of the Supreme Court's decision on other courts that come after it. And we do hope that the issue will, of course, transcend all the way to the Supreme Court, and we will get proper direction on what is the impact of that change of the law. That is the only thing I wanted to add to the very wonderful presentation that Darren has made on that question. Thank you.
Now we will ask Dudley to give us a couple more comments if he has any. If not, we will move on to the next question. Councillor Dudley, did you have anything else you wanted to say on the topic, please?
Yeah, I think Luciana is right that the decision of the Supreme Court also has a disruptive effect. You remember it has come in after the close of the period for filing of the other petitions. So people have already filed their petitions relying on what the court had said in 2017, in the hope at least that it would be better, it would clarify the standard better. But it has now muddied the process. Perhaps the only window of mercy is the court says that we see no need at this stage to tinker with the standard of proof, but there's real need for the court to look at that issue of standard of proof. And that's why also, I think I agree with Owiti that the petitions are beyond the parties. It also speaks to the law. It informs other petitions. The Supreme Court's role is also legislative. It develops the law in the terms of Article 20 and 259 of our Constitution. Thank you so much. I'll stop at that point for now.
So we shall now move to our co-moderator, Julie. Do you have a further question? Thank you.
Thank you. I think Dudley's last comment has actually prepared a proper segue into the question that we wanted to ask the panelists, and particularly those who are parties, the petitioners, the respondents, and Amici Council, around questions of potential constitutional reform. One of the key recommendations from the judgment is a considered opinion around whether we should expand the 14 days. I've already gotten Council Dudley's opinion of that. I would be interested to hear Professor Sihanya's and Dr. Muthomi Thiankulu with me here, so I'll be coming to you on that question. But there are other recommendations that the Supreme Court judgment makes. For example, it actually points to IBC that they should have a separate server to ensure that once issues of scrutiny are ordered, it is not barred by administrative technicalities. So the recommendations that are there in the Supreme Court judgment are meant to guide processes of reform. So from your analysis, are those recommendations enough? Should the Supreme Court have gone further to give further recommendations for potential consideration, both by civil society, by advocates, by parliamentarians, by drafters? Are there things that have been taken out from this particular experience that we can now use to work for the next 5 years on to ensure that we have a better electoral system? So I'll start with Dr. Muthomi Thiankulu, because you're here. So you can start, and then we'll go to Professor Ben Sihanya, and then I'll invite Dudley back to give holistic comments around constitutional amendments and constitutional reforms emanating from the judgment. Thank you very much.
Sienna, on the question of standard of proof, in fact, I would add, Dudley, the Supreme Court has never been right on this matter, even in 2013, because there has never been any legal or policy justification for the intermediate standard. An election petition is substantially a civil dispute, even though allegations of criminality frequently feature in those proceedings. And I believe the main thrust of the proceedings is to establish the validity of the election, and the question of the criminality is always an incidental matter. It is not the primary focus of the court. I have always thought that the problem we have on this issue is, number one, our Supreme Court lacks the humility to acknowledge when it has gotten things wrong. So unlike what you find in other apex courts, the other apex courts, you find many decisions, from the UK Supreme Court, previously known as the House of Lords. You see many from the former East African Court of Justice. You see decisions. Just recently in the United States, they were overruling a precedent that had been there for over 30 years called Roe versus Wade. I think because of our elections are polarized and divisive in Kenya, our Supreme Court judges are hesitant to acknowledge that our decision issued on this day upon further reflection was wrong, and therefore it is hereby overruled. I really look forward to such a sentence in judgment from our Supreme Court, because they are common from other superior courts or other Supreme Courts. And for me, this intermediate standard was something invented out of something I usually call legal sophistry, just playing mind games with litigants in the country when you don't want to confront the problem head on. If you ask me, there has never been any logical, legal, or policy justification for the intermediate standard. I prefer we have either the criminal standard or the civil standard, just one standard. On the question of reforms, I agree that there are definitely problems with the 14 days. It is inadequate, and therefore it denies the court a chance. First of all, it denies the parties the opportunity to properly assemble a good case if you're a petitioner. And it is even more unfair if you're a respondent. Speaking about this just headed round, your petition has 7 days. You're a respondent, you're served with 9 petitions. One of them is a track full of documents, and you have only 4 days to respond to all of those things. It's clearly not practical, and whereas there may have been good reasons, and there is a third reason why this is problematic. Our constitution, Luciana told us, says that other courts are bound by decisions of the Supreme Court. By giving such an unreasonable period of time, you deny the Supreme Court the opportunity to write a good quality decision, so that then you find our electoral law jurisprudence will always have all these gaps. I'm one of those who are usually very strong critics of the Supreme Court on other occasions, though today I seem to be on its side on the question of the language. But the point I'm making is that if you give the court an unreasonable period of time to decide such a weighty dispute, you will inevitably end up with a decision that either has wrong suggestions or the conclusions of law, like often happens, or a decision that is not very well reasoned, and that therefore is not ideal for purposes of setting precedent for the lower courts. I agree. Unfortunately, in this country, when you mention the question of constitutional reform, again, because of our history, it evokes very strong reactions. Then it also arouses very opportunistic behavior. If we talk, for instance, this matter would have been perfectly addressed in the so-called BBI. But then because constitutional reform is also a political process, the challenge in my young years and limited knowledge of how Kenya works is you front this proposal, and then the political class will, in their usual partisan ways, see that as an opportunity to load other things that are not, easy to agree upon. And therefore you will have with, and for me, if I had my way, unfortunately, constitutional reform is a political and democratic process. If you ask me, the biggest constitutional amendment Kenya needs, which no one talks about, is one that just talks of a single presidential term. You can call it 8 years, 6 years. And the reason I mention this is very few people seem to realize all the instability associated with our elections usually comes when an incumbent president is seeking re-election. when we have a transition election, 2022, 2017, we don't usually have serious problems. But when you have an incumbent, because of, again, our historical problems, we were just colonized the other day, and I don't think most of our people have democratically matured to accept that even an incumbent president can lose an election and he is supposed to peacefully hand over power. No. So if you ask me, although the idea may not be popular at the political stage or it may not even gain traction, one of the things that will really stabilize our democracy is a single-term presidential, so that even these disputes, and to me, Italy is very well even with the idea of increasing the time, because the guy is having only one term. We can debate whether it's 10 years, whether it's 8 years, whether it's 6 years. Then you make even a stronger case, then therefore the court should have even better time to resolve a dispute like that, given there will be no other chance. If this guy is sworn in, then he takes over and he gets out of the scene.
Now that is an interesting proposal. Professor Ben Sihanya, what do you think about that proposal, as well as the other proposals that are in the judgment itself? So the proposals that I think we want to tackle on is the question of the 14 days to resolve the dispute, and also some of the recommendations to the IEBC, particularly on its governance questions, be it new policies, internal policies, but also legislative amendments to IEBC. So you can talk about the recommendations that are there within the Supreme Court judgment. Over to you, Professor.
Yes, okay. Thank you so much. Before I address the issue of policy, legislative, and probably constitutional amendments, let me just briefly say that Dr. Mugdomi Tiankolo, in rebuttal, what I thought was on the basis of issues already discussed, he came with new evidence. So I need to address that briefly, a few seconds. Number one, there were so many issues about the presidential election petition which were approved. For instance, that forms 34A on the portal were black and white. They ought to have been color. There were problems with the issue of, actually one of the counsel for the respondents even said that please ignore that form 34A, yet it was on the portal. Why were they on the portal, and why were we relying on documents that now in the court we ought to ignore? I think that was senior counsel Ngatia, actually. That issue was not confronted. What was Camargo doing in the system? And that issue has not been confronted, including his name and stuff like that. And what nature of contract did he have, and when did it terminate, etc., etc. Those are issues which were very, very important. And lastly, on the question of the 2017 logs, Mr. John Gidongo answered that question and filed an affidavit that helped clarify that. And as we all know, this is also Con Law and Evidence 101. Witnesses swear affidavits on the basis of information, knowledge, and or belief. And then they state the basis of that, whether it was on information or on knowledge or belief. And should there be any problem, you should compare this evidence vis-a-vis that. It's not an issue to be said from the bar or from the bench that this evidence is not credible, and especially in an adversarial system, until there is systematic comparison of evidence. And of course, it was really the court went on overkill, and by siding with the respondents and really attacking very personally, even advocates, let alone as well as Mr. Gidongo, without being heard, the court was in this case being the complainant on the behalf of the respondent, the prosecutor or counsel for the complainant, and also being the judge. They even just fell short of saying that we cite you for contempt, which was completely out of order for that is the only court that has jurisdiction on presidential election petition. In the court of first instance, and it's also the final court. And that cannot be the process that this country, according to the constitution, according to the law, that's not. So let me just go on this issue of the recommendations, and they can be related to policy recommendations, legislative recommendations, as well as constitutional recommendations, constitutional issues. Let me just start by saying the issue of 14 days. Three-pronged. Number one, Kenya has 14 days. Kenya did not have this before 2010, and we know what used to happen in what happened in after 1997 elections. Matiba, sorry, 92, Matiba v. Moi. After 97, Kibaki v. Moi. And the electoral petitions used to last forever. And in the meantime, the president had been sworn in. And we know sometimes by candlelight, like in 2007, when Kibaki was sworn by candlelight in State House at midnight. So this is what used to happen. And therefore, things move on, accept and move on. And therefore, even the electoral petitions were just formalities. And I think there were too many technicalities of procedure followed. So 14 days was supposed to be a position whereby let us resolve this dispute before we go to swearing in the president, swearing in the president-elect, or should we have to have another election, then we can do that. Well, as has been discussed this afternoon, other countries approach it by 30 days, others 180 days, others no timeline. And please also note that in Tanzania, there has been no presidential election petition because they had decided that, but now in the amendment, constitutional reform process in Tanzania, they are saying that we should have actually presidential election petition. South Africa, which is another interesting jurisdiction, is that they don't have a direct presidential election. It is parliament that does it. So, and that also has its own complexity. And many times it's the majority party in parliament, many times has its way like ANC. So those are some of the issues. And there are merits and demerits of a short time span and a long time span. Neither of them is perfect. A 14 days time span could be good if it's implemented effectively, because it doesn't allow anybody to start claiming incumbency and start manipulating the levers of political power. However, in Kenya, we have seen that even though there have been election petitions, whether in 2013 or 2017 and even 2022, there have been moves to manipulate the political process and the power structures so that the person who either is favored by the processes seems to exercise directly or indirectly certain powers, or they start buying MPs and stuff like that. That has also happened to either consolidate the power or something like that. Those are some of the problems. And lastly, there have been reform efforts can be made on this particular issue of 14 days. And in the BBI, this was one of the issues. And the judiciary and JSC and the judiciary had actually recommended 30 days. And that was going to be implemented through BBI. And I'm glad that many people now recognize that BBI had some very many good points. So 30 days was regarded as being reasonable, a balance between too short a time span, which gives too much pressure on the petitioner and sometimes also the respondent, or too much time that makes some people consolidate power and therefore difficult to remove. My problem is this. So if you see IBC, like the recommendations that the Supreme Court is making, take example on IBC, on corporate governance issues. Parliament should consider enhancing statutory and regulatory framework on the separate policy and administrative roles in IBC. Part of that was done, separating policy from strategy. Policy, strategy, and oversight belonging to IBC as commission, and admin, day-to-day admin belonging to the management. And that has been done, and I think the Supreme Court should have acknowledged that. But here they are not very clear, because the issue was the role of commissioners vis-a-vis IBC chair. And that was the issue. And I think in the argumentation, it was very, very clear that, so the Supreme Court here is being a bit not candid. This is not candid because these issues were well articulated. And lastly, on this issue is that then if there was a problem here, there seems to have been a problem. Even this is an acknowledgement that there was a problem. Why did then the petition succeed? Because there was a problem here. From a consumer perspective, it is very, very clear. And from Maina Kiai Supreme Court, from Raila Supreme Court, it was very, very clear that the chair had exceeded his limits. And this suggests that the Supreme Court was aware. And so these recommendations look like a PR exercise, an afterthought to try and assuage the feelings that the Supreme Court was not being candid and was not being forthright, that there was a problem in their findings. IEBC ought to effect formal internal guidelines that clarify the delineated policy, etc. Then the roles of chairperson, they are saying there, a chief executive officer, etc. I think there's an acknowledgement that there was a problem. And I won't go to an lecture on technology because a lot has been done on that, but just to say that to avoid suspicion from stakeholders, that also is an acknowledgement that there's a problem with the issues of 34A, 34B, 34C, which is again gives us the issue of tallying and verification and declaration at national level rather than this. Like, for example, 34A is the only one that is at the constituency level. It's at a polling station level. So 34B is at constituency level, 34C is at national level. So any statement I've had before, for example, from Dr. Tiankolu, that president is elected and finalized at polling station level is clearly wrong and accepted by the Supreme Court here. Servers ensure that the servers supporting the elections and those serving internal administrative are distinct and separable. It means that there was a problem, and the Supreme Court was not being candid by unlike the Maraga Supreme Court in 2017. But I want to be very clear. In fact, on the day of the determination on 5th September, I was on NTV and I said this, which I repeat. This Supreme Court had given us the impression that they are a very serious court. And I want to repeat that they have given us Sonko decision, which I like, on integrity, including the question of whether somebody who has been impeached can run again. That's a good decision. This Supreme Court has given us an interpretation of Muruatetu on the death penalty questions, mandatory death penalty, which I think it can be debated, but then they give us a very good decision also called CDF. So in my view, this Supreme Court has decided to be a pendulum. When things are normal, okay, they give us very good decisions, Sonko, CDF, Muruatetu. But when it appears that there is a judicial capture, then they give us the Raila 2022. And I think anybody who is observing the Supreme Court is even seeing that they are going out of their way to line up in political processes and line up in political environment. So why not give us judicial orders? Why go to recommendations? Recommendations are not the main entry point for a Supreme Court. The main point is judicial orders, judicial directions. So this is an issue which will be debated into the future. And we hope that the Supreme Court will avoid being a pendulum, much as we know that in most countries, Supreme Courts tend to have a political role. And I've discussed this in Nairobi Law Monthly before. Political in capital P, not political in small p. Political in the sense that it is supposed to balance certain difficult political questions, political interests, but balance it on the basis of constitutional text, constitutional structure, and constitutional history. Not on the basis of whims and then coming to really abuse many Kenyans by using such sensational language as hot air, etc. So the Supreme Court should have cast these recommendations as orders, and surely this shows that the petitions had succeeded on the merits. Thank you.
To Dudley Ochiel for his proposals, comments, critiques of the recommendations given in the judgment.
I think I have none, but I would fault Prof. Sianya a little bit for not recognizing the concession by Mudomi Thiankol, who has every reason, to defend every bit of the decision. But I think fairly magnanimous, he says that there's an issue in the Supreme Court's willingness to depart or to reverse itself, and concedes that the issue of standard of proof has been glossed over by the Supreme Court. But it's the most important bit. I think the Supreme Court has only ever reversed itself twice. Once in Raila 2017, saying that no, we were wrong about the interpretation of Section 83. It should be or, not and. Either quantitative violations, little violations that have a quantitative effect on the outcome of the election, or a qualitative pollution of the electoral environment. I think just that for now. Oh yeah, the other time when the Supreme Court reversed itself was on the omission of interest. In one of the cases I argued, I think that should have been Musembi. It had returned the High Court's judgment, restored it, but then omitted the interest, with interest, damages with interest, and then it returned that. I'm not aware of any other situation when the Supreme Court has, over the last 12 years now, reversed itself. Thank you.
Dudley, I'll invite JV Owiti to actually give his sentiments on the proposed legislative, policy, constitutional amendments and guidance from the court. Thank you.
Professor Sihanya's comment that probably the recommendations were an indication of admission of impropriety or irregularities. It's possible that that is true, but it could also mean that despite the irregularities, they did not reach the threshold that would lead to a nullification of the election. So that's one. Secondly, borrowing from Prof again on the issue of whether or not the 14 days would affect, the swearing in or the return to a fresh election. I think 14 days, in my view, for the reasons that have been given, are very few, are inadequate, insufficient in terms of the paperwork and the pretrial requirements for a presidential election. It could be extended to 30 days as has been proposed. And then if that, the fear would be about whether or not the incumbency would come in, then we could also push the date within, the number of days within which to swear the president-elect if confirmed as having been validly elected, or push the number of days within which to hold a fresh election from the 60 days that is provided for. Those would be my comments. And finally, on the issue of the recommendation to IBC to internally come up with policies. I think every issue is context sensitive. In the context of our current IBC and the squabbles that we've seen even at the Supreme Court, I don't think it would be a proper recommendation to have them come up with internal policies. I hope that our parliament, which may also be very partisan in terms of the politics of the day, will take up this important role and come up with proper legislative amendments or even fresh new statutes to try and fill the gap and the lacuna in the law that has allowed the conflict that we've experienced. Because the IEBC historically has been chaotic because it seems to be involved in the partisan interests of the day. And finally, I agree with Professor Sihanya that the Supreme Court should have done more than just merely make recommendations. Recommendations have very little weight. And I have looked at the Supreme Court Act. I don't seem to find the basis of the court making recommendations. The court should talk like a court, make declarations and make directions, not mere recommendations. Thank you.
All right, thank you very much to my able panelists for dissecting what I believe is a very interesting judgment. Key issues are coming out, and we have also seen that Participants have been keenly listening in and also sharing their comments. So I want to invite my co-moderator, Valentine, to take us through some of the comments that have been raised by the viewers who are here. We would have asked that someone could raise their hand if they want to voice their question. So if you do wish to voice your question, you can raise your hand and the technical teams will enable you to voice your question. But otherwise, we will take the questions as written in the chat and then have our able panelists unpack them. So over to you, Valentine.
Thank you, Julie. We've received a number of questions, and for now, I am going to ask each panelist one question, which they can address at the end of my running through the questions. So the first question is from Topua Lesinku, who has a question for Dudley Ochel. What recommendations do you have regarding improving our results transmission system? And feel free to make reference to countries like in the United Kingdom or Scandinavian countries like Switzerland, where they use voting by mail, and they actually have a barcode in which they can register their votes and confirm later online that those manual votes have accurately been captured. So that is the question for Council Dudley Ochel. Another question from Topua Lesinku, who seems to be an avid supporter of the series. This one is for Council Thuo regarding election observer funding and whether government should fund this. Some of the participants in the 2022 election claimed that they were unable to substantiate the claims just because of funding issues, and even the availability of observers at most of the polling sites was not possible because of funding issues. So who should fund this, this exercise, and to what extent, please? The third question goes to Dr. Muthomi, and this concerns the Form 34As, which he described as the gospel bearers or the touchstone in any election, because they're more about coalescing results as opposed to tallying. Can you explain to us what the difference between the two, coalescing and tallying, is? What did you mean? There's a fourth question from Oyugi Miller, and this one is directed at Council Professor Sihanya, please. Please, can you give us further recommendations on what you would see in an ideal IEBC? And there's a fifth question from Joshua Onsare. This one is for Council Omwiti. And he's saying that what other methods of rebuke are there beyond language for judicial officers? Professor Sihanya, can you also please speak more on what you described as judicial capture? We've got a request for that. So thank you. I think we can begin with Council Dudley, if you're ready.
About the mode of improving the transmission of electoral results, I think we are continually improving our electoral systems. And that's one thing that the petitions help us to do. And so that the court should invite more petitions so that the law is developed. It's also a peaceful outlet for the tensions that come after the elections. I think the 7-day wait creates some unnecessary tension. And a lot of things are happening, fake news and things of the sort, false hopes rising and falling on both sides. There was a joke going around at some point that, when one day is one side's turn to be happy, the next it's the other side to feed on the anxiety. I think we feed on that anxiety because we still haven't developed things like projections, exit polling in other countries, and also electronic voting and transmission. In the morning, and by the evening of that day, they know the outcome of the elections are. They know who is winning and who hasn't won, and then they go on to other things. Maybe as we improve our electoral systems, we can go fully electronic to incorporate electronic voting. I think that would be a way of full improvement. but then you'd have to have another layer of accountability so that whatever happens can be verified. I wasn't really myself satisfied with the court's conduct of the scrutiny this time. I can't speak much on it, having been acted for counsel, but I remember in 2017, for example, the court had a court-appointed expert who accompanied the verification team. I think this time was not missing. The ICT people that I saw, I'm not so sure, the beyond court staff and court clerks who did a wonderful job. There was an independent expert appointed by the court to help the court conduct the scrutiny. So in short, as we go forward with our elections, we can push them to be fully electronic. That would quicken them, and that would fully automate the result, the voting and the result transmission system. Of course, subject to checks and balances and measures for accountability, verifiability, and transparency. Thank you.
Before we go on to the other panelists to address the questions raised, I'd like to call on two people who have raised their hands. I'll start with Bishar Ibrahim. You can ask your question, and thereafter we'll call on our friend and fellow counsel, Evans Ogada, to also voice his question. So we'll start with Bishar, then Evans Ogada. So Bishar, you can unmute your microphone.
Yeah, thank you very much.
All right, thank you.
Thank you very much for the seniors who are on the panel. My question is in regard with the post-judgment action we've seen on the social media, and maybe some of the senior lawyers commenting on when the Supreme Court pronounced itself. So, and we are now facing serious issues and now dividing, the country on what to do on the judgment on how we can, mitigate it on the real issue. The judgment has already been delivered, but now there's a problem of people inciting that how we can remove the Supreme Court judges, on how maybe, all those things are created by the political. So my question is how can we separate the law, the judicial officers that are there, and the words of the politicians? We also witness that our lawyers are also become nowadays, and maybe the senior mentors on the Republic of Kenya, becoming a politician rather than speaking the truth that on the judgment. So my question is, I'm actually directing to Professor Pensia, is how can we differentiate politics and the judicial officers? Because we know that those are the judicial officers. The Supreme Court judges are not politicians, and they have the discretion. That's why we put them there. But now the politics is now overtaking the, everything, claiming that, how we can remove, how they mishandle things, how they are partisan, and all those things. Thank you very much.
Thank you very much, Bishar, for your question. I'll call on Evans Ogada to also voice his question, then we can take both of them together.
Julie, good afternoon. Can you hear me?
Good afternoon, Council. I can hear you very well and clearly.
Thank you very much. I see so many of my friends across in Nakuru and Nairobi. Thank you very much. Mine is not a question per se, but it's something I quite passionately believe in, and I think my teacher and good friend Elisha Ngoya has had me enough times on this. The conduct of the Supreme Court time and again raises concerns. The language you use, the body language, is quite important. And the bigger picture moving forward for the country will be how that court behaves itself in terms of language, in terms of the messaging. It does not bode well, and I'm not speaking about substance here. I'm speaking about the language used by the court. In the context of raw emotion, in the context of heightened concern, it does not bode well as concerns the language that the court used. We are seeing a pattern, and we also saw it during the BBI when certain councils were mentioned, and you mention council's name, reprimand them, subject them to ignominy, and you leave it at that. The court has enough tools under the Advocates Act and then the Supreme Court Act to pronounce itself legally. The court has no business to give us emotional arguments. So moving forward, that court has to be cognizant of the legal capacity and the tools it can use, and not give or yield itself to emotional narration. Thank you very much.
Very much, Council Evans Ogada. Now we will turn to our panelists as guided by our co-moderator Valentine Haminwa. Thank you.
Thank you, Evans, and thank you, Julie. We will now go to Senior Lecturer Ms. Thuo. Please, could you field the question regarding who should fund election observer missions and audits? Thank you.
Okay, I think we are talking about two distinct analyses and separate processes. So starting with election observation, election observation missions are funded by the respective groups that have an interest in assuring themselves of the credibility of the processes. And the reason why they are separate from government activity is because we use outsiders as a measure of acceptability of our processes. If we are to judge ourselves on the standards on elections, then we might not achieve the international standards on election because it will be partial in our assessment of ourselves. And that is why we accept to accredit election observer missions, whether from the African Union or elsewhere. The US, the Party Center, has been consistent election observer. We also have the European Union mission consistently coming. The idea being we want to assure ourselves, first of all, that we are doing the right thing, which is why we are open to learning from them, but we are also telling you we have nothing to fight. If it was a government-sponsored process, it's unlikely that we would have the level of transparency that outside observers bring to the process. So I don't think funding should come from the government for that. When it comes to election audit is a post-election process within the election calendar. And we've been following the report of the IBC this past week. IBC has already switched into the post-election audit phase. They tend to prepare a post-election report using government funding ideally to assess what they did wrong, what they got right, and how do they prepare them for the next election. Challenge that the IBC has had is the IBC after Section 21 requires the IBC to table estimates to Parliament for approval for funding, and you've heard them say that repeatedly in the PPI process. They have a challenge with getting funding for the activities that they need. The IBC has been pushing, just like the judiciary, to have the establishment of the IBC fund. That has not yet worked. So for now, they have to depend on Parliament to give them money to do all of their activities, including state election work. There was a question by Nikwa also on the question of technology and whether we should be investing money in observing or technology. I would flip the question because I don't think the question is about the technology. I think the question is about the concept in which the technology operates. Technology ideally was to add a new layer of verifiability, accountability for what was essentially a manual process. Technology in and of itself cannot assure us of a free, fair, credible election. It has no capacity. If technology operates in a political context that manipulates the technology, then what the technology was meant to do in terms of adding an additional layer of transparency, accountability, verifiability is law. So I don't think the question is whether we should be investing your money in technology. I think the question is how do we fix the environment that we operate in, such that we stop distracting the technology that we employ in the election management cycle. Until we fix that context question, until we fix questions around threats of unauthorized access to technology, then no matter how much we invest in technology, we will always have questions like the concept of doubting the credibility of the result that has been declared by the IBC. That is how I would answer those two questions. I will give it more back to the moderator.
Thank you very much, Senior. We shall now move on to the question of 34As, being the touchstone truth. Please, Dr. Muthomi, can you speak to us, especially in view of the sentiments of Professor Sihanya that there were even black and white 34As being uploaded into the system? Thank you.
Is the touchstone of truth is because this is the form filled at the place where the election takes place at the polling station. It is filled in the presence of candidates. or their agents and observers and many other players. And it is the primary document, therefore, prepared in circumstances where there is very little room for fraud and for error. Then the technical question was, what was the difference between collation, tallying, and I would add even verification, although it was not asked, because all these are terms used in the relevant constitutional text. Now, one of the problems with the English language is you find the meanings of words sometimes overlap. If you check your dictionary, to collate is to collect information from different sources for purposes of examining and comparing it, which is exactly what happens at the National Tallying Center. They are collecting all these from 34Bs from the 290 constituencies. They are collecting all these from the 4A from the 46,000 polling stations. Then when you check the same dictionary for the meaning of tallying is to compare two or more sets of figures or data to see whether they match. And it also says to tally is to calculate the total number. And I think earlier on in the debate, I had used the word tallying in its arithmetic sense, which is to calculate the total number that is in that context. Then I said the commissioners or the 4 commissioners were gravely mistaken if they thought that the outcome of the election was a matter for their vote as a plenary. Then it says to verify is to check whether something is accurate, which is again exactly what happens at the National Tallying Center. The commissioners and the staff and the chairman of the IBC would compare the form on the portal against the original, against the entries in Form 34B, and once they are satisfied that all those entries, because there will be repeat entries of basically the same information, then that is what is meant by verification. So if you ask me the 3 terms, and it's not correct when Professor Sianya was suggesting that the word collation is not used, I think it is expressly used in Article 86, paragraph C of our Constitution. And I want to suggest these words, it's not an accident that whenever you find them, Article 81, 86, 138, often they go together, tallying, collation, verification of results, and whatnot. So to me, I hope I've answered the question as to whether, what is the meaning and import of these terms. It seems the question of language still doesn't go away, going by the sentiments from my very good Mr. Ogada. And again, I will invite us, whenever you open any word in your dictionary, the dictionary actually gives you an indication of whether that word is to be used in a context of approbation or disapprobation of human behavior. So you find your dictionary, for instance, will flag out before it even gives you the meaning. It will flag for you that this word is slang. It will flag for you that this word is colloquial, which means it is not to be used in serious, formal, whatever. It will flag for you that this word is no longer considered, although it's part of the English grammar, it is no longer considered appropriate to be used in certain contexts. And for me, what I am not able to see is someone showing me a dictionary that shows any word used by the Supreme Court that is in the realm of an insult, that is in the realm of slang, that is in the realm of a curse word like the F word people throw around, that is in the realm of personal ridicule, ridiculing the person and the dignity and the integrity of a person. I don't see any single word in that judgment. Forget the 2 phrases that are being bandied around. I haven't seen, and I would challenge anyone who is complaining about the language to show me, because luckily the dictionary, I want to imagine there are like 10,000 words in a typical dictionary. And for every one of them, besides giving you the grammatical meaning, the dictionary actually shows you the appropriateness of the use of that particular word.
Thank you very much, Doctor. So I'd now like to move to Professor Sihanya. Unfortunately, time is not on our side. So within the space of 2 minutes, if possible, can you speak to us on the question of judicial capture and IEBC reforms, please? Thank you.
So thank you. Let me start by saying, Dr. Three things. Number one, Dr. Tiankolo, the issue why I talked about that telling issue is that you were saying that it doesn't apply. Everything has been done at the polling station level. Fine. Three basic things. One is about the reforms in IEBC to make it an ideal IBC, what some people have called in this debate, the ideal IBC. That's number one. Number two is the question of judicial capture. Okay. And that any issues arising from that. IEBC has been a big debate way before even. Okay, let me just start by saying that elections used to be conducted under the auspices of the supervisor of elections. Then we went to, who was in the office of the Attorney General. Then we went to the office of ECK. Then, and initially the president had a lot of powers in that appointment, and later on in 1997, there was inter-parties parliamentary group, which agreed that the political parties, parliamentary political parties should have a say. And that is also the process in many other countries to make it accountable, because there is no neutral human being in this world. If you give a bishop a vote, they will vote for somebody. And here we have known how partisan they have been, etc. So the idea was that we need to, the idea was that we needed an electoral management body, EMB, that is sensitive to the political undercurrents of the country. So there's nothing like total neutrality. Then we went to IEBC, and there's been a lot of debate. So the main issue here about reforming IEBC would deal with a three-pronged approach, and most of them have to do with human resources and inculcating integrity and leadership integrity, chapter 6, which is really threatened. Chapter 6 is really, really threatened because it has been weaponized in Kenya over the years. Unfortunately, in most of our presidential administrations, gives us serious problems. So that's why when you hear that some people are saying that Chebukati is a hero, it's because we are killing chapter 6. So we need to talk about, one, the chair and the commissioners, the reform there. We all know that in 2016, December, we had interviews, and which gave us some very good candidates, but the chair was not one of the top candidates in terms of leadership, integrity, professional, academic, and related qualifications. That's on there for the record. And that we did not pick our best when we had many better ones. That also applied to the commission. So there is a need for reform here on those issues of leadership and integrity standards, academic qualifications, professional and related experiential qualifications. Then number two, number two is the question of CEO and management, and there have been issues here as well, whereby we should also look at the similar parameters. There are some reasonably good people, but there are also people who have been so partisan over the years. Then there is the issue of the field staff, those who manage it, and most of them are normally also appointed to be returning officers or presiding officers over the years. Some are based in constituencies or counties, etc., etc. So the reform of IBC is not just about the chair, but the main problem here is an HR problem. It's not, the technology is innocent, but technology is an issue of garbage in, garbage out. And in the IBC, it has been garbage that is fed into the process and that gets out. So that also relates to a very major issue that has arisen in 2017, Raila, in Malawi, Professor Mutharika, the election petition regarding Professor Mutharika, Peter Mutharika, and also in the debate, I think that was DCJ Mwilu, I think during the debate in Raila 2022, who the point has been that IEBC and other beneficiaries of IEBC's corruption and incompetence, and in IEBC, the line is either absent or thin on the question of whether it is incompetent or corrupt. The line is either non-existent or thin. And whenever beneficiaries talk, they say, where were your agents? Agents are important, yes. But Malawi, Raila 2017, and DCJ Mwilu raised the issue of don't always point to us where were your agents, because IEBC lawyers were trying to say that. That's why you have the constitutional and legal mandate, and you have the resources to make sure that the elections comply with 81, 86, etc., etc. But of course, we acknowledge the role of agents. And then that gets us to the last question here of judicial capture. I've worked on this for quite some time, and it's not just the flip side of state capture. Judiciary is part of the state, of course, and part of the government. But I've been working on it from the perspective of those rallies. In the same way, when judges line up in a political event, we must ask those questions. It's a question of both perception, but then you can relate it to either past or ongoing decisions that are happening. And just this past week, we've seen quite a lot of movement on leadership and integrity cases. Those which had been more or less like concluded, reopened. Those which had been, etc., etc. So, and I'm consistent on this, and I've written chapters on this in my book, Constitutional Democracy, Regulatory and Administrative Law in Kenya and Africa, which is also online. That our presidential administrations have been consistent in weaponizing the integrity and leadership issue. And unfortunately, sometimes judges. So the issue of judicial capture can be three-pronged, and it's a case-by-case basis. There are some cases where individual judges make certain decisions that you can perceive or are actually influenced by the politics of the day. Number two, when a bench, a 3-judge bench, a 5-judge bench, or even sometimes a 7-judge bench makes a decision that you can see is not based on the Constitution, the law, and the evidence, but is probably influenced by political developments, recent political developments. And lastly, is when not just a bench, not just a few benches, but many benches make certain decisions that you would say that what is the problem? Is there trouble anywhere?
My apologies, but I have to cut you short there. Unfortunately, time's not on our side, but I think we've got the...
Thank you, I finished.
So now over to Julie for the closing remarks, please.
Oh, yeah. Before I do the closing part, I think JV Owiti had a question to respond to and also a tie-out. Sorry.
Oh, my apologies. If you can manage within 30 seconds
Yes,
to give us a synopsis of what you would recommend in terms of rebuking a recalcitrant counsel, aside from language by the judge.
Great. I already mentioned that the Supreme Court has power to cite and punish for contempt under Section 28 of the Supreme Court Act, and fine you up to 500,000 shillings, or send you to jail for 5 days, or both. The judiciary can recommend punishment by the Advocates Tribunal, Disciplinary Tribunal, under Section 61 of the Advocates Act. There's also the possibility that you can be recommended for investigations by the the Complaints Commission. So the Supreme Court has powers. In fact, Section 28 says that if the powers under the Supreme Court Act are not enough, then the Supreme Court can exercise the powers equivalent to the High Court in punishing for contempt. There is also Section 113 of the Penal Code, and Section 114 of the Penal Code, which talks about false swearing in cases where an advocate may be accused of swearing false affidavits or even obstructing justice. So the Supreme Court has a whole bag of tools which should not make it fall back to strong language. Thank you very much.
Thanks a lot, Counsel. Thank you, Counsel. Now over to Julie, please.
Thank you very much to all our panelists. Indeed, this has been one of the most interactive webinars that we have held, and a lot of our discussions cannot end here. So we will definitely continue with the discussion. It is now my distinct pleasure to invite Mr. Elisha Ongoya, a senior lecturer at Kabarak University, an ardent advocate of the High Court of Kenya, and a litigant before all the courts that we have discussed today, to give our closing remarks and also to close out this webinar. Over to you, Elisha Ongoya from Kabarak.
Thank you so much, Julie, at the studio at ICJ Kenya, and thank you everyone who has sat through this process from the beginning up to this time. I'm a proud convener of the Avid Readers Forum at the Kabarak University Law School, which is a forum for intellectual discourse and discussion of intellectual ideas. Allow me to very briefly thank the heads of the institutions that have put this together, starting with my own boss, Dean Professor John Osogo-Ambani, who has fully supported us to make this event a reality. LC, ICJ, Christine of Katiba Institute, the Kenya Human Rights Commission, all of whom have stood in queue to make it possible for us to assemble here and discuss as we have done this evening. Let me acknowledge the very heated and intellectually sound conversations of our panelists, and I'll say something about these people. Professor Ben Sehanya, my own teacher of comparative constitutional law way back in the year 2005, 2006. Dr. Mudomi Tiamkolu, my own contemporary at the University of Nairobi almost 2 decades ago. Ms. Luciana Tuo, my student almost a decade ago. Mr. J.B. Owiti and Mr. Chair Dudley, both my students a decade ago. I'm very proud to sit in this intergenerational equity environment where my own intellectual father and my own intellectual children have engaged in a discourse in a manner that is fulfilling to the true nature of intellect, which is regeneration of intellectuals. Our moderators, Julie and Valentine, as usual, they have been up to the task. We'll come back to you yet again when similar duty calls. I'm aware that Dr. Victoria Miandazi is with us online. Victoria, pass our regards to the entire institute that we are partnering with for future programs of this nature. And allow me to acknowledge those behind the scenes, the men and women whom we never see, but who make this delivery even possible. Mr. Kadima, Mr. Stanley Mayaka, Sejaret Gakombe, Mario Joy, David of ICJ Kenya, Johnston Achanga, the producer of this program today, we acknowledge you. And more importantly, my student, Ichwen Kemboi, who have wished I answer one question, to which I say, kulingana na mimi, sina maoni. Sina maoni kabisa. We also thank our online audience that have been faithful to us. Our numbers oscillated between 131 to 200 online this afternoon. And our studio audience at Kabarak University, where we had more than 300 students taking this event as a formal class as part of their learning of constitutional law. We acknowledge and appreciate you. And for everybody who has made it of this, we appreciate you. And all I can say is, God bless you. And that was the end of our event this afternoon.